My name is Stan Welsh. I'm a Boise attorney, and part of my practice involves estate planning and probate. I'm going to address for you some information on advanced care planning documents, oftentimes called a living will, a term that I've always wondered why we developed that term, since it usually involves dying, not living, but we've called it living will. It also is not the same thing as a will that you would do or may have done already through an attorney, where you're providing for what happens with your estate when you die. The Medical Consent and Natural Death Act is set forth in Chapter 45 of Title 39 of the Idaho Code. My last reference to the Idaho law, but a place you can look if you want all the details on this particular law. This is the law concerning the consent for health care services. The law specifically provides that nothing in the law is to be construed to permit or require the provision of health care services contrary to your stated or implied objectives based on religious grounds. In other words, there's not a specific language that you have to use, although there are some really great forms that you ought to use. Advanced Care Directive or Health Care Directives are referred to documents that meet the requirements of the Idaho law, or is any other document that represents a component of your authentic expressions of your wishes concerning healthcare services. And again, these are generally healthcare services dealing with end-of-life planning. One other item to look at is a physician order for scope of treatment. It's called POST. This is an order regarding scope of treatment signed by an independent licensed practitioner, a physician's assistant, or a nurse with particular qualifications. The POST form has some special provisions that you may talk about with your doctor. The doctor is going to have the form that's going to be used. And if you do use this form, there's also a POST identification device that you can wear. It's a special device. So this is something you may want to consider. In my experience, it has not been something very many people do. But if you have some special concerns that you want, then you may want to consider using this POST form. The advanced care planning document can be signed by any competent person who is 18 years or older. The law provides an order of priority for who can sign for someone other than the age of 18 or is not competent. I frankly have not yet seen that in my practice where somebody that's under age 18 or not competent that they want to sign a form for. But there's an order of priority. Generally, it would be a guardian ad litem or normally a parent if it's a child under age 18. The advanced care planning document is referred to an advanced directive or living will. And the living will, as I mentioned earlier, is a term that most of you have heard of. It has to include your name, your date of birth, your telephone number, and your mailing address. It has to include your signature by you or the authorized agent. It also has to include the date the document was signed. Those are the only items that have to be in this document. There are a number of other items that most are going to want in the document and that they're really used for. It would include an electronic mail address. It would include a nomination of one or more persons to act as your healthcare agent. This is the person that would act in your place to tell a doctor or your healthcare professional what type of treatment would be given. It would have the name, mailing address, electronic mail address, and telephone number of any person or persons nominated as healthcare agent. And you'll see from the form, when you go to the forms, that'll have a first person, an alternate, and then sometimes a second alternate. These are typically going to be family members. They don't have to be family members. They can be anyone you trust to make decisions that you would want to be made for your healthcare. They would include resuscitation instructions. In other words, if you're not able to come back out of it, do you want them to bring you back? Instructions regarding pregnancy, instructions for the release of information protected by the federal law dealing with release of healthcare information. Again, instructions for end-of-life care, a description of the treatment objective, a name and contact information of witnesses to the execution, and notarization. Notarization is something interesting because at one time this was required. At one time we did have to have a couple witnesses. That is no longer required by our current statute on living wills or these type of forms in Idaho. These forms do vary from state to state. So the fact that if you live in Idaho, have a living will, and move to another state, you definitely would want to look to see what the law requires in the state where you move, to see whether they have anything special, like does it have to be notarized? Do you have to have witnesses? How to complete the form. The forms are available on the Boise Diocese website. I'd urge you to go to our website for the Boise Diocese, and you can look there, and it'll give you instructions on the site, on how to fill this out and do that. Another site, which is a very good site, is from the Idaho Department of Health and Welfare. You go to the Go to Advance Directive, and you can download the form. You can also then email the form back to the Department of Health and Welfare, and they have a registry where they'll keep the form. The form then is made available by healthcare professionals if there's a need for them to see what your healthcare directives were. You should always discuss these with your family members and, of course, with the designated agent, somebody that you're asking to make this important decision, what to do for some end-of-life planning. Completing these forms, again, are very simple. They're self-explanatory. The one thing, again, I mentioned earlier is there's a durable power of attorney for healthcare. That's the person that will make the healthcare decision if you can't make it and if you have not given specific instructions. The rest of the form is a form that's very self-explanatory, and essentially the primary things that are done on the form goes from saying, I want no additional care given if I'm not going to come out of a coma or if I'm not going to come out of this, or to going to have water, to have nutrition, again, or have nothing. The forms are very self-explanatory, and you can elect what you want to have included. Something that you'll want to do, the one thing that the forms do not do, and none of these things do, is say that they will not provide care to remove pain and suffering. So that's going to be given no matter what you say. They're going to relieve pain with whatever treatment is necessary. So those are the forms to use. They're very easy, they're very user-friendly forms, and it's something that everyone should have.